Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Let's get straight to the docket. First, Lori Vallow had court today, and she was nothing but smiles. Will we get to see the affidavit filed with the court to search Mar-A-Lago? Well, the judge said he will decide on Thursday. Alec Baldwin doubles down on the gun just went off defense, cases dismissed, and then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk. My name is Scott Reich. Thanks for watching. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and remember you can listen to us on your favorite podcasting app anywhere where you listen to podcasts. All right, I made it back from the road trip from hell. I will talk about that more tonight, along with our first story that we're going to talk about, Lori Vallow, tonight, 6 p.m. Mountain Time when we go live. Please join us. So let's go ahead and open the record for August 16th of 2022. All right, Lori Vallow went to court today, and she was all smiles, both during and after. That's right. Lori Vallow appeared in court Tuesday with her attorneys, and they argued the language in the grand jury indictment against her needs to be much more clear. Jim Archibald and John Thomas, Lori Vallow's attorneys, believe two of the counts listed in the indictment are complicated and will be too confusing to the jury because they include two separate allegations according to their filings. And the judge, Judge Boyce, kind of agreed with this. And what had happened is the attorneys for the prosecution, when they did the indictment against Lori Vallow, is that they said that there was a conspiracy to commit murder and the grand theft, which was the money to take from the children from the public benefits from Social Security. And so that's the theft. The defense is saying, hey, this is too complicated for the jury. And the prosecution is saying, well, it's not complicated. And the defense says, well, no, it is complicated because you're basically saying there's kind of three different crimes here. You got the conspiracy, you got the murder, and then you have, with an and, not an or, the grand theft. And so where it could get confusing is yes, a conspiracy is an agreement to commit an illegal act, but you have to show an overt act to start the conspiracy. If I'm just sitting around with my buddy and we're saying, hey, you know what? We should rob a bank. That's not a conspiracy. But if I say, hey, you know what? We should rob a bank. You go pull the car around. I'll get the masks and some weapons. We've taken that step to go do something, an overt act. The defense is saying, hey, this could be confusing because, Judge, we're going to have to define all of these elements of the offense. The prosecution says, hey, our standard jury instructions that the Supreme Court has approved says we don't have to do this. I think the judge is a little concerned about the language and how it's written. The question is, and I've mentioned this before, is do they have to go all the way back to the grand jury? Well, if I was the judge, given this a death penalty case, I'd say go back and do that. Do it correctly. But then you have to represent all the evidence to the grand jury to come with that. It's kind of complicated. Or could it just be solved by giving very detailed jury instructions with further clarification? That's probably the clean fix that the court will decide. But I think the court is a little concerned and even commented, I've never seen it charged this way. And, we'll go from there. And the prosecution also argued that, hey, Judge, this was filed late and you shouldn't even consider it. However, just as expected, the court said, you know what, given the complexity and nature of this case and the discretion that he has under 12B as it relates to the timing of the filing of motions, he found good cause. The court did not take up the motion regarding the consumptive DNA testing because of the stipulation that we talked about the other day. You can go back and look at that video if you want more explanation. Basically, everybody agrees to what they could have agreed to about 6 months ago, so this could have been done and completed because, as I mentioned in that video, there's only 4 months until trial. Just saying. Equals delay. There's no way they're going to get it done. The other motion that was not brought up by the court was the motion filed by Lori Hellis, who had filed a motion to intervene, saying that she thinks the court is not following the appropriate procedure when sealing court records and conducting sealed court hearings, and that the court should not do that any further. No word on when that motion will be held. Now, Chad Daybell and his attorney, John Pryor, did not attend the hearing. They, along with Lori's attorneys, were originally set to discuss the motion about the DNA, but as I stated, they reached that agreement. Next on the docket, the judge is supposedly going to weigh the unsealing of the affidavit behind the FBI search of former President Trump's Mar-A-Lago resort. So, before we get to this story, I want everybody to take off your political lenses, okay? Let's try to look at this objectively. Now, when I talk about this, literally I get comments saying, first, why do you hate Donald Trump? And then I say, I don't hate Donald Trump. And then I get other people saying, you are some sort of Trumpster. You're not looking at this objectively. You suck. You're the worst person in the world ever. Not picking a side here, ladies and gentlemen. Let's look at this objectively, okay? So we're going to look at not because you either hate Trump or love Trump, but let's just look at it from a legal aspect, which is what we're talking about here, the legal aspect of it. So a federal judge in Florida is set to hear argument Thursday to make public the affidavit laying out the evidence which led to the FBI search of former President Donald Trump's Mar-a-Lago home, as investigators begin to pore over documents that were seized from the residence. Now, let's face it. Today is Tuesday. They conducted this search last week. There's not that much. I'm sure a team of agents could have gone through those boxes by now. Just saying. Now, the affidavit would provide a little bit more detail to everybody about the FBI's investigation than what was contained in the search warrant, which was unsealed last week by United States Magistrate Judge Bruce Reinhart. The inventory search, which was also unsealed and released, showed that the agents removed from the property about 11 sets of classified documents, including some marked as top secret and meant to be only available in special government facilities. Now, the Justice Department has asked Judge Reinhart, who approved the initial warrant to search Donald Trump's residence, not to unseal the affidavit. So the government, let's just be clear, the government doesn't want to unseal the affidavit. The government argues that the release would compromise future investigative steps and likely chill future cooperation by witnesses whose assistance may be sought as the investigation progresses, which is interesting because I thought the purpose of the search warrant was to get the documents that were apparently taken to Mar-a-Lago when they shouldn't have been. I thought that was it. What other ongoing investigation would there be? Okay, just something to think about. Now, in the filings by prosecutors, they said that they would object to making public some other less sensitive information associated with the search warrant. Now, the affidavit itself would serve as a roadmap, obviously, to the government's ongoing investigation, which they described as an intensive probe involving highly classified information. I guess they could redact the highly sensitive information, but since that was the purpose of the search warrant, was to get these highly sensitive documents back, and that's been taken and done, I would think they're either going to, like I said, 20 some odd agents there going through 11 boxes. I mean, I'm not the fastest speed reader in the world, but I could probably do that pretty quickly, even with only 11 boxes. If it said classified, top secret, that'd be pretty simple. So I would expect if there was a crime being committed, the charges would be filed post haste. Just saying. Or if there's a greater investigation, what you're telling me then is the reason to go into the residence was not just to get the documents, but part of a greater search warrant investigation? Now, just saying. Somebody is not telling the truth when it comes to this. Okay? Somebody's. And I don't know who it is. If President Trump is lying, really what it boils down to, you would think, is that if these documents were declassified as the president alleges, there would be some sort of paper trail, some sort of documentation, right? That's what people do in the government. They document things, I would imagine, for the president. So it shouldn't be that hard to determine whether they were declassified and no crime has been committed, or if they weren't, that they have now found the documents, that the charges should be filed immediately because a crime has been committed. And why would we want to drag this on forever? Somebody's not telling the truth, and I don't know who it is. Is it President Trump not telling the truth, or the government's not telling the truth? But when they say that it's part of a bigger search warrant, color me skeptical. Maybe it's just those many decades of being a criminal defense attorney where the cops use different methods to advance their investigation and maybe aren't as completely honest as they should be. And this has nothing to do with President Trump. I'd say this if they were going after, I don't know, Ghislaine Maxwell, for example. So, in a posting on his social media platform, the former president said, "I call for the immediate release of the completely unredacted affidavit pertaining to this horrible and shocking break-in." Well, Mr. President, it wasn't a break-in. Technically, they had a search warrant. And if charges are filed, or you think that your constitutional rights are violated, you could always file a 1983 action against the FBI and those particular agents that maybe trampled upon your constitutional rights if you believe that's the case. Just throwing that out there. Now, Justice Department and his officials have defended the search as necessary step approved by Merrick Garland, the Attorney General himself, after he apparently spent weeks deliberating the issue, which is kind of weird because if it was such an easy, straightforward, clear-cut decision, you would think that what's the problem? What do you need to deliberate? If a crime's being committed, no one's above the law, go execute it. And by God, as I would say it, charge him. If you think he committed a crime, charge him. Now, people familiar with the Justice Department approach have said that the primary goal of the search was to ensure the security of these highly sensitive national security documents after the Trump team didn't relinquish the documents. They were concerned that the security of the material at the Mar-A-Lago had been put at risk. The alleged documents obviously were protected by the Secret Service. So are they saying the Secret Service is incompetent? I don't know. And as we noted, the FBI took around 20 boxes of binders and photos and handwritten notes and an executive grant of clemency for Mr. Trump's ally, Roger Stone. A list of items removed from the property shows. Now, also included in the list was information about the president of France, according to a 3-page list. The list is contained in a 7-page document that also includes a warrant to search the premises. The warrant, not the actual affidavit, which is the information they provide to the judge to establish probable cause to show that a crime is being committed. That list includes various documents marked with TS or SCI documents, an abbreviation that refers to top secret, sensitive, compartmented information. It also says agents collected 4 sets of top secret documents, 3 sets of secret documents, and 3 sets marked confidential. The list didn't provide any more detail about the substance of the documents. And this filing by the government came in response to requests from media outlets, including the New York Times, Wall Street Journal, to make public the documents, which would explain what evidence, including witnesses the government had collected, and describe why investigators believe that a crime may have been committed. The warrant itself was unsealed only after the Justice Department urged Jen Reinhart to release it, a move that Attorney General Merrick Garland said he directed in light of Mr. Trump's confirmation of the search on the day that it happened and the substantial public interest in the matter. Now, the FBI has returned 3 passports it recovered from Mar-A-Lago during their unannounced search of Donald Trump's residence last week. Now, it was reported on Monday evening. Now, first, the FBI said they didn't take any passports, but then they returned something they didn't take, apparently, which is interesting because they were there to recover documents that were marked confidential, secret, top secret. I wonder why they took the passports. It almost sounds like a general search, which would be prohibited under the Constitution. Just something to think about. Here's my hope, ladies and gentlemen. I hope that they relieve the affidavit. We have a right to know if former President Trump committed a crime, or was it the federal government using the search as a harassment package? We have a right to know. Release the affidavit. Let the chips fall where they may. Bottom line, we all have a right to know. We have been very vocal about the public's right to know in matters of great public importance. And if the former president has committed a crime, we have a right to know. And if government believes that he's committed a crime, we have a right to know what evidence they're going to rely upon to do that. This isn't just some routine everyday case. It's something involving the President of the United States that went to the highest levels of the Department of Justice. if they have dotted all their I's and crossed all their T's, it shouldn't matter. We'll see how things play out on Thursday. Next on the docket, Alec Baldwin doubles down. That's right, a very frustrated Alec Baldwin insisted he did not pull the trigger of the gun that killed cinematographer Helena Hutchins. He is claiming again that the faulty gun fired on its own and that the only question to ask is who put a live bullet in the stunt weapon. Now, Baldwin is awaiting a decision from the prosecutors in New Mexico, who must decide whether he should be charged over the incident that occurred last October. They are yet to make a ruling and are now no doubt weighing the FBI report that was released last week that said the gun could not have possibly gone off without Mr. Baldwin deliberately firing it. Now, Mr. Baldwin apparently told a podcast that he has grown tired of waiting for a decision from prosecutors, but that his attorneys have told him not to push anyone. Now, the interview appears to have been filmed before the FBI report was made public, but the video was published on Tuesday morning. Now, you can understand Mr. Baldwin's frustration. Like, if you've got enough evidence for a crime, charge it. If you don't, let me get on with my life. We're talking last October. We're coming up on 10 months now. It took 10 months to determine that the gun could not go off without somebody squeezing the trigger. Oh my gosh. As I seem to recall, Scott Reich here in Crime Talk brought in his antique pistol of that same era to show months and months ago that the gun could not go off, okay? Firearms of today's are a little more complicated, uses a much different system, but that old revolver, you got to pull it. You got to pull the trigger, ladies and gentlemen. So I understand Mr. Baldwin's frustration, and I frankly agree with him. The prosecutors, you know the facts, you have it on video, you've got the report, either charge the man or let him go, okay? The stress is unbearable, which is a nice lead in here to our next story. So criminal charges have been dismissed against at least 100 people for lack of prosecution by the district attorney. So criminal, felony, and misdemeanor charges against nearly 100 people have been dismissed on Monday by a magistrate because El Paso district attorney prosecutors have not taken action on their cases. Another 300 dismissals are expected this week, according to the El Paso County Public Defender, Kelly Childress, whose office sought the dismissals. He stated, quote, "As a society, we've come to consider accusations as some level of proof of a crime being committed, and it's not," Mr. Childress said. "If we, on the inside of the system, don't put value behind the presumption of innocence, we certainly can't expect juries to. For me, I was shocked that it got to this point." Now, the motion to dismiss the charges and the discharge to bail were filed under Article 32.01 of the Texas Code of Criminal Procedure, which requires prosecutors to indict accused people within a certain period, normally within 180 days after a person's initial arrest, according to the public defender's motion. The whole purpose of Article 32 is to prevent citizens from being left in jail or on bail for long periods of time without actually being indicted. What a radical concept. In the cases dismissed on Monday, the district attorney's office had not filed the case with the district clerk or sought a grand jury indictment for well over 6 months to more than a year on some cases, according to the public defender. So as of April 20th, the DA's office had more than 5,300 cases in screening that were waiting for a decision on whether to prosecute, according to information from open records request. And Monday's dismissed charges range from DUIs to assaulting police officers to drug possession. About 1 in 4 of the dismissed charges were against people accused of assaulting a family member, i.e. a DV. The dismissal also meant that any of the protective orders imposed on someone as a part of their bond were now removed, which could have immediate implication for alleged victims without a protective order in place. Now, Assistant District Attorney Adam Shevner did not object to the motion to dismiss. Even with the dismissals, the district attorney's office is still capable of bringing charges as the cases are still within the statute of limitations, which in Texas apparently can range between 2 to 10 years for most cases. And when cases are awaiting for prosecutors to decide whether to move forward, defense attorneys are not entitled to discovery. We don't know who the witnesses are, and you're unable to preserve different forms of evidence that we might need at trial. So over time, those things diminish. It makes it really hard to try a case when the arrest happened a year earlier. Another 100 dismissal motions are expected to be heard on Tuesday, along with 100 more on Wednesday and another 100 more on Thursday. Now, Monday's motion hearing started late because the district attorney's office didn't show up, didn't bother to send a prosecutor to be present in a hearing, which is going to result in hundreds of cases being dismissed. What did the DA's office do? They sent a paralegal from the DA's office who arrived late after the hearing was supposed to start at 9 o'clock. You know what she told the court? The prosecutors are really slammed right now. That's why they sent me here, she said. Well, the El Paso County Magistrate, Humberto Acosta, who presided over the dismissals, told her that a prosecutor had to be present at the hearing. Duh. Wow. El Paso better get their act together down there, man. I don't think they're going to, dismiss hundreds of cases and then go back and refile just because, it's within the statute of limitations. They're not going to do it. But in the meantime, once again, allegation is out there floating over somebody. You either got it or you charge it, okay? If you have enough information to charge them with a crime, you charge it. If you don't, you tell them. Case closed, we're moving on. It's a no file. Next on the docket, dumb criminal of the day. Can you imagine what's it gonna involve? Yes, you're right. Today it's another food at Burger King, and I don't know if it's a trend why people are assaulted at fast food restaurants more than say Ruth Chris Steakhouse. I'm not exactly sure. Don't get me wrong. I love a good Burger King burger. I'm even down for McDonald's fries. Thank God I've never been assaulted there. Well, an argument at Burger King, it's alleged that a Florida man threw a cheeseburger at his girlfriend with such force that when the sandwich struck the back of her head, the woman fell over a curb onto the ground. That's according to the police. Now, according to the criminal complaint, James Hunt and his girlfriend and cohabitant argued Saturday afternoon about the victim not eating her food. Seems like a logical argument to have. Why aren't you eating your food? I'm not hungry. Eat your food. But I'm not hungry. I'll take it with me. Eat your food. Yep, that's what took place. And this was in Clearwater, sitting near Tampa Bay. Now, the dispute turned violent, according to the police, when the woman began to leave the restaurant. That's when Hunt allegedly threw the cheeseburger at the victim, striking her in the back of the head. This action caused the victim to fall over a curb onto the ground. The victim's chin and lip then hit the pavement, resulting in abrasion and a cut. Now, upon arriving at the Burger King, cops observed blood on the victim's shirt and shorts and cheese on her shirt and in her hair. Need I say more? That's not a smoking gun. I don't know what is. Well, a Burger King worker told the police that before Hunt walked away from the restaurant, he struck the victim in the head while she was on the ground. Now, while Hunt reportedly admitted to throwing the burger at the victim, he denied striking her while she was down. Hunt also told police that he did not think the cheeseburger strike caused her to slip on the curb and fall to the ground. Well, guess what? He's been charged with felony domestic battery, and Mr. Hunt is being held in the county jail on a $15,000 bond and has been ordered by the judge to have no contact with the victim. Now, Mr. Hunt, who's identified as a mechanic in court papers, has 2 prior domestic battery convictions, both of which go back to 2002 in Arkansas. No information as it relates to if a deadly weapon such as a cheeseburger was used. I know. I can't make this stuff up, ladies and gentlemen. All right, a couple of things. First, thank you very much for watching. Second, please join us tonight, 6 p.m. Mountain Time here on YouTube. so we can do our live show. And then our Patreon show will be immediately following that for our Patreon members. We'll be talking about the news of the day, including Lori Vallow and the infamous affidavit for the search warrant for Mar-A-Lago. Please join us.